We'll first call case number 23-40601, Covenant Clearinghouse versus Trinity Falls Holdings. Mr. Fourmaux, have I pronounced that correctly? We'll begin with you.
May it please the court, my name is Jeff Fourmaux, counsel for the appellant CCH. This court should reverse the bankruptcy court and hold that the sale order below is void, and that the real covenant at issue remains in effect for 3 reasons. I'll state all 3 very briefly and then elaborate if you'll permit. First, CCH is trustee for beneficiaries that owned a valuable recorded interest in real property, specifically a real covenant recognized by Texas common law and statute. In a judicial proceeding, such as the sale motion in the bankruptcy court, aimed at eliminating their real property interest, the due process clause required actual notice to CCH and the beneficiaries, not just publication notice. That's because the names, addresses, and vested interests of the covenant's beneficiaries were all undisputedly known to the debtors. Under Mullane, the debtors should have given them notice by mail, but did not. As a result, CCH did not learn of the bankruptcy and the sale order eliminating their interests until nearly 10 years later.
So how do you reconcile your position with the termination clause?
Sure. So first off, the termination clause was never exercised here prior to the bankruptcy. It wasn't exercised at the time that notice should have been given.
Right, but shouldn't we construe the existence of the property right in light of the fact that it's a unilateral at-will termination clause?
No, absolutely not.
Or do you think I'm misreading the clause?
No, absolutely not. The Texas Court of Appeals addressed this issue in the City of Friendswood decision that we cited in our brief. That was a case where there was a subdivision divided into lots. It was subject to a restrictive covenant, not allowing use for anything other than residential purposes. But the covenant provided that a majority of the lot owners could terminate the covenant at any time by a majority vote. They executed an instrument recording and then recorded their majority vote in the county records.
There was a recording here, wasn't there? When you say that they did not exercise the termination clause, what does exercise look like to you? What do you mean by that?
Sure. An exercise would look at, there are in paragraph 25 of the declaration, there are requirements for how a termination is to proceed. And the requirements are, it's a written instrument, it's executed by the declarant, and it must be recorded. And it must be recorded prior to a sale, conveyance, transfer, or assignment of the property.
And it's your contention that that did not happen here?
Our position is that it did not happen here, that it, first off, I want to make something very clear here. Whatever rights the debtors, who were the declarants, whatever rights they had to terminate unilaterally, that ended when they entered into bankruptcy. Why? Because the debtors themselves had a 56% interest in the covenant. They themselves were beneficiaries of the covenant. So when they went into bankruptcy, that meant their 56% interest in the covenant was a valuable property of the estate. And when the debtor in possession is in bankruptcy, it can't, and when they asked the bankruptcy court, please authorize us, approve us, and direct us to follow the termination procedure. They recognized, the debtors, they recognized that they couldn't do that unilaterally on their own volition. Again, because doing that would mean eliminating property of the estate. When you're in bankruptcy, the debtor in possession cannot simply destroy a valuable property, a valuable asset of the estate on its own volition. That's reflected in Section 363B1 of the Bankruptcy Code, which says that a debtor in possession can sell, use, or lease property of the state other than in the ordinary course only after notice and a hearing. It's also in Section 554A of the Bankruptcy Code on abandonment. A debtor cannot abandon property of the estate except after notice and a hearing if the property is burdensome to the estate or of inconsequential value.
Counsel, let me ask you, and you may have touched upon the answer, what course of action would your client have pursued had it been provided the notice that you claim it was deprived of, and with what expected relief or result?
Sure, absolutely. So I think that's two questions. If I'm understanding the first part correctly, is if they had been given notice in the bankruptcy, what would they have done? So if they had been given notice in the bankruptcy, they would have taken steps to protect their interest. So there's testimony in the bankruptcy court below on the motion to set aside that, for one thing, they might very well make a bid on the property. Property sold for $27 million after the auction. They valued the property at more than $30 million. They might have come in and made a bid. They also valued the covenant itself and the present value of the income stream from the covenant in the 8 figures. So they would have come in and taken steps to protect their interest. So, for example, when the debtors proposed to the bankruptcy court, please insert a provision into your seal order saying that cause exists for us to terminate covenant, and please approve, authorize, and direct us to do so. Parties in interest, like my client, should have had notice and an opportunity to be heard as to whether that was actually in the best interest of the bankruptcy estate and its creditors. One of the things that often happens in bankruptcy is that orders are the result of negotiation between the parties when they all get a seat at the table and they can talk to each other. That's emphasized in the Second Circuit's decision in Motors liquidation that we cited. In that case, the court said, even if that involved the automaker bankruptcy and there was an issue over future claimants for some ignition switch failures. And the Second Circuit said, well, even if those claimants wouldn't necessarily have a legally valid or convincing objection to make, it's still important for them to have a seat at the table. So, because negotiations go on in bankruptcy, and that's one way people protect their interest, and therefore we find that even if harm were required to establish a due process violation, we find harm here. Now, just to be very clear, harm is not required in order to establish a due process violation. This court has said that. Most other courts have said that. The Supreme Court has said that, because the problem is the loss of your day in court. And in Schroeder, the Supreme Court said, notice is a vital corollary of the right for an opportunity to be heard, so that the person, so the interested party, can decide can choose whether to appear or default, acquiesce, or object. So, it's the loss of our day in court, that's the harm. And I described some of the things that we might have done to make an objection, but to be very clear, the due process violation occurs whether or not you would have actually made an objection, whether or not you would have had a good objection, whether or not you would have prevailed on the objection. That's been made absolutely clear in Supreme Court and in this court's case law. So to go to your second question, what prospective relief would we want here? Well, this court, not too long ago, in the 2021 decision in its Mitchell Law Firm versus Bessie Jean Werver Revocable Trust, 8F 4th 417 423. This court held that when an order or judgment is found to be void, the court has an inherent power to undo the effects of the void order. And that includes restoring rights and property that were taken away from the person as a result of the void order. And so therefore, I would say, ultimately, whatever the legal effect may be of the termination that was purportedly performed by the debtors after the entry of the sale order, indeed a day after the sale closed, whatever its legal effect, those were actions that the debtor could only take because they were authorized and directed by the bankruptcy court to take.
So your arguments that you were entitled to receive actual notice assume that you're a known creditor of the debtor, correct? What is your best case, or am I incorrect about that?
I'd have a slight correction to that.
Okay.
Because this is not about what the due process clause does not say. No person defined, no creditor, as defined in the bankruptcy code, shall be deprived of their claim as defined in the bankruptcy code without due process of law. It's not about creditor or claim status. The entire discussion in the lower courts, most of which focused on, let's parse the definition of creditor and let's parse the definition of claim, that was absolutely the wrong question to be looking at. The question is whether they had a property interest that was affected by the judicial actions taken by the bankruptcy court. And they did here 3 times over. So, first, the declaration of covenant here, by its terms, created a covenant running with the land. And the Texas Supreme Court has held, and the Texas Courts of Appeal have held, that a covenant running with the land is a real property interest, not a contract right. That's in Inwood, that's in City of Friendswood, that's in Griffin Park that we cited in our brief.
Did you raise those party and interest arguments based on the covenant running with the land language in a declaration before either the bankruptcy court or the district court?
The status of the covenant as a covenant running with the land was referenced referenced throughout the bankruptcy court proceedings and in the district court proceedings.
And was it both briefed and addressed in argument, or was it just addressed in argument?
It was addressed in argument. I believe it was recited in the briefs, but there was, certainly it was raised, along with, there were many issues raised.
Do you have a record cite? Do you have a record cite that makes clear that you preserved these arguments?
Your Honor,
It's fine if you
I
want.
actually did in a longer version of the outline that's sitting in front of me.
That's fine. You can bring it up during your rebuttal time.
Sure.
Thank you.
But it is it is noteworthy that, appellee's counsel in the bankruptcy court at the hearing actually said at page 213 of the June 10th, 2022 hearing, yes, maybe they have a property interest, but it was terminable at will. That was Judith Ross for They weren't the appellees there, but the opposing party. So there was discussion of,
Well, let's turn to that. Let's turn back to that issue about terminable at will. You mentioned the Friendswood case as your critical case. It wasn't terminable at will in that case, was it?
yes, it was terminable at will by a majority of the lot owners. A
That's
majority of
very
the lot owners at any time could get together and decide that they wanted to end the covenant. And so as to the minority lot holders, it could be terminated against their will. Can I find, so,
That's quite.
can I find
quite a
something that's
difference.
exactly, precisely these facts of this case? No, this is a case that involves very specific facts. But that's a case where there's a covenant that could be terminated against the will of the objecting beneficiaries. And nonetheless, the Texas Court of Appeals said that was a property interest.
Right, I mean, there are a lot of property rights that can be subject to majority vote rules of the homeowners association and communities and whatnot. What I'm not familiar with is the notion that there's a property right that is cognizable in court that is unilaterally rescindable by just the act of one person. Do you have any case that stands for that proposition?
I don't think we've seen a case that deals with this precise type of situation, and neither have the appellees. That's why we hear this business about.
Well, why isn't it just a matter of common sense that something that exists essentially as a matter of grace by one person really isn't a property right?
No. The declaration was recorded in the year 2009, and it begins by saying that the declarant hereby declares the property to be subject to the covenant running with the land that's set forth herein. And so it presently created a covenant, and then it went on at paragraph 17 to presently vest various beneficiaries with a present interest in the covenant. They had a vested right. It existed until it was divested. That never happened as of the time of the bankruptcy petition, as of the time of any of the sale motions or other activities in court that we were not given notice of.
Thank you. Your time is,
Thank you, Your Honor.
you've reserved 3 minutes
Yes.
for rebuttal. Ms. Sotak. Have I pronounced that correctly?
Yes.
Sotak.
May it please the court. This interest that CCH claims under this covenant is unique and different in two significant ways from any other property interest that's been recognized to be substantial enough to require actual notice by due process. Those two ways are the first one that you've been focused on, Judge Ho. And that is that it was terminable at will at any time at the pleasure of the debtors. There were no restrictions on the ability to terminate. There's no property interest recognized in any form that is like that. And in fact, one of the things that appellant cites, they just pull out different cases, different property interests, helpful language from different pieces of cases. But if you look into those cases, one of the areas that they looked at was about reversionary interest. So interest given by a grantor that's a fee defeasible upon a condition in the future, or a fee subject to a condition subsequent, so a fee interest that would end upon the happening of an occurrence in the future. And they say, well, that's a property interest, and so this is similar to that, and that's recognizable, and so thus you ought to do that. Even in those sections, however, the point is the restatement sections for those two interests, both defeasible interest and condition subsequent, the restatement sections say, to the extent that the interest granted and the future condition is solely within the volition of the grantor, we don't have an opinion about whether that actually creates any interest at all. And the reason that it doesn't is it's commonsensical that to have a property interest, someone has to have a legitimate claim to entitlement of a benefit under that under that instrument or under that interest, CCH cannot ever claim to have a legitimate claim of entitlement to a benefit under the declaration when that declaration is terminable at will by the debtors without any notice or otherwise to CCH or any other party that could be affected by that termination.
Okay, so you're saying that the the restatement doesn't take a position on provisions like this,
They don't take a position, but
or that it sort of goes out of its way to not take a position.
Correct.
While
There's a-
contrasting it with other types of.
the restatement says that some of these future conditions that control these future conditional property interests, that sometimes those can be to the, that sometimes that those can be valid, and those can result in a valid property interest that then can revert to the grantor. Underneath those sections, and it says specifically, caveat, we do not take a position on whether, to the extent the future condition is solely within the volition of the grantor, creates any interest at all, suggesting like the common sense thing. That's not creating an interest because you're not really granting anything when it's subject to the at-will termination of the grantor.
Did you cite this in your red brief?
No, we did not. I mean, we.
I'm looking at it.
No, the
You have a citation for us?
No, yes, it's the restatement sections 55, the restatement of property sections 55 and also 35. Excuse me, the restatement sections 44 and also 35. 44 deals with fee simple determinable interest, and 35 deals with interest subject to a condition subsequent.
Okay, why don't we do this, to the extent that you're asking us to rely on non-cited authority, is you'd be welcome to file a 28J this week, by the end of this week, identifying that for us, and of course, opposing counsel will have the opportunity to respond
I would
within that same time frame.
happy to do so. Now, that is just one factor. The unique feature of this declaration being terminable at will is just one factor that distinguishes this declaration from any other, from any of the other things that appellant says that makes it a property interest. The other distinguishing.
Before we move on from this, was there any kind of hearing on either the termination issue or on the sale?
And before what court?
Before the bankruptcy court?
The bankruptcy court held a hearing on the sale motion.
On the sale motion, okay.
Yes.
All right.
The other thing that distinguishes this, CCH says, well, this is a covenant running with the land. Well, let's examine that for a second. Is it, though, in the hands of the debtor? Let's look at what the declaration says about what the debtor is obligated to do. The declaration in paragraph 6 exempts the debtor from paying any transfer fees under it. The declaration in paragraph 8 says any lien that may attach to the property only attaches for unpaid transfer fees and only arises when a transfer fee that is due is not paid.
All right, so your point is that they're not a creditor,
My point is that,
not a creditor of the debtor.
right, my point is that they are not, that this declaration doesn't obligate the debtor to do anything. It doesn't obligate the debtor.
They're referring to downstream sales.
Correct. Well, I'm referring
Why
to
isn't that a viable interest?
why in the downstream sales.
Right. I mean, I get that there's an exemption for the original owner. I forget the names of the parties. But I assume you also agree that subsequent sales, they would have a 1% right.
Well, sure, but that's
Why isn't that a viable interest?
in the hands of the debtor. There's nothing created there. And from the debtors, CCH or the beneficiaries have no, because they have no legitimate claim to entitlement. The reason they say, well, it's a covenant running with the land, and it was intended to run with the land, and it has all these features of a covenant running with the land. But that's not so. Texas law says a covenant running with the land has to, at a minimum, touch and concern the land, have an intent to bind the debtors, or with obligations on the debtors. There's not a single covenant running with the land case that has been cited to this court that doesn't bind the debtor. This one does not bind the debtor and has no obligation on the debtor, likewise has no obligation on the debtor, on the property in the hands of the debtor. There's no burden placed on the property to service a covenant while it's in the hands of the debtor. All of those things are going to be to some later person. And as you know, yes, maybe that might be potentially an interest, but that interest was subject to being cut off by the debtors unilaterally and without notice to any of them, including when they continue to say that the beneficiaries had a vested interest. If you look at paragraph 17 of the declaration, the beneficiaries' rights in and to the declaration are explicitly made subject to the debtor's right to terminate under paragraph 25. That paragraph 25 is clear about the debtor may at any time prior to a sale of the property at any time may record a termination and effectively cut off all of those rights. And so for those two features of this covenant are what distinguish it from every other type of argument that CCH continues to say that it is. We already talked about why it's not a covenant running with the land for two reasons. One, it doesn't bind the debtors, and it doesn't burden the property in the debtor's hands. It doesn't touch and concern the land, and there is no intent for the debtors or, no intent to bind the debtors or to run with the land until after the property is sold by the debtors, assuming it's not terminated. Then if you look at those homeowners association cases, which are usually also covenants running with the land or restrictive covenants, there are two things that are different about those cases and ours. One, in the homeowners association cases, liens are filed or considered filed to secure payment of the homeowner's assessments at the time the declaration is filed. This one is not so. No lien arises under this declaration until there are unpaid transfer fees that are due. There can be no unpaid transfer fees that are due under the property in the hands of the debtor because the debtor is exempted from paying them. And the other big difference between the homeowners association cases and this case is the homeowners association say that the mandatory community membership and mutuality of obligation is that inherent property interest. Here there is no, the debtor is not a member of any homeowners association. The debtor is not obligated to do anything under the terms of this declaration. Thus, that doesn't get them there either. The next argument that they have is the one that we already discussed about these contingent reversionary interests. And that argument fails because in none of those contingent reversionary interest cases, usually the occurrence of the event in the future is that you use the land as a park or something like that. In none of those cases that they've cited to you is that contingent future event solely within the control of the grantor. Then they tell you, oh, well, it's not that, this is like a tenancy at will case, or, there's other situations in which that this would be a recognized property interest, and they cite tenancy at will cases. And then they say, well, and also Fuentes, and the bankruptcy court can't remove an interest. The distinguishing factor between those cases, the tenants at will cases, they already have the possession of the property or the residence, and they have an expectation that that will not be taken from them. In one case, subject to the lease, a holdover lease, that's in Slavas. In the other case, they cite in terms of a statute that provided certain rights to them, like, that required the government to have a hearing and evaluate whether alternative accommodations could be made for them. So those people have an interest that CCH doesn't have. They can't point to anything that they currently have that was terminated by the sale order. They have nothing under the terms of this declaration as it is at the time of the sale order.
So do you have a sense of how common how common it is that people would record rights that are terminable at will unilaterally in this fashion?
I don't have a good sense of that, Your Honor.
In other words, is this your sense that this is a common provision? Is it an unusual provision?
My sense is that CCH and they licensed this and went and recorded it for all kinds. I mean, they were the authors of this declaration, and to get developers to enter it, I don't know if that's what they had to give for that, but I mean, this declaration, these are common enough that, you know, in 2011, the Texas State Legislature outlawed private transfer fees moving forward, and that many other states likewise have also done so because these declarations of this exact type were proliferating out there. I don't know, I mean, I'm not aware of any other like things that are recorded in the real property records that are terminable at will. And, you know, that is the point that given those two features of this declaration, you know, the terminable at will aspect plus the fact that it doesn't obligate the debtor to do anything or obligate or burden the debtor's property in any way, the property in the hands of the debtor, you know, that this really is the interest that CCH or the beneficiaries have under this declaration is much more akin to the employment at will context. That's the closest analogy that we can find there. You know, yes, do they have some interest? Of course, they want those interests to be there in the future. An at-will employee wants continued employment and hopes for continued employment, but what the due process cases say, and every single case addressing whether or not, you know, that an at-will employment situation gives a legitimate expectation of continued employment, they all say it does not. And
So let me test that analogy. The way employment at will works, I mean, you obviously described the law correctly, but there is sort of a mutuality of benefit, right? But typically the employer and employee can count on the continued relationship just on the assumption that it'll be continually beneficial, not as a legal matter. Is that true in this context? Is there any expectation by the other side that your client would want to continue this provision?
no, and in fact, you know, look.
That's what makes this provision kind of, to me, unusual, right?
Right. I mean, there's no question that CCH and the beneficiaries and the others maybe hoped that, you know, the property would be sold and developed and that they would make a lot of money off of transfer fees over the 99-year term. However, as far as an expectation.
But I guess what I'm asking is why did the declarant agree to this provision in the first place? What's the benefit to the declarant?
What is the benefit to the declarant? The declarant.
That's the employer analogy, right? We understand why employers hire employees.
Right. The declarant is also a beneficiary.
How so?
The declarant is a named beneficiary. If you go to paragraph 17, they are named beneficiaries of the declaration. They are 56%.
I'm sorry. I meant how do they benefit from the 1% transfer fee?
Because the 1% after they sell it, okay, one, they benefit because they don't have to pay the transfer fee, right? They don't have to pay the transfer fee, but after they sell the property to others that then sell it down the line, the declarants for the next 99 years will continue to receive. If you look at paragraph 17, I believe that they are 56% beneficiaries of this declaration, so they will receive 56% of the transfer fees collected over the next 99 years, less whatever the trustees' fees are.
Okay, so they get a cut of it.
Correct.
But they also have the unilateral right to
Correct.
cover the entire transfer fee.
And they also have the unilateral right to terminate it. And, you know, to the point earlier, you know, to your point, Judge Douglas, about how do you exercise the termination and when is the termination effective? All the paragraph 25 says is they've got to sign it, they've got to and record it prior to a sale. It doesn't say any day, it doesn't say when that termination is effective or as of what date. You know, so in our case, what we argue is that termination was effective as of the date of the sale order or as of the date of the recording. Both of those were prior to the sale of the property to the original buyer out of bankruptcy. You know, I want to address the other point. You know, CCH says, well, you know, once the debtors filed for bankruptcy, they didn't have the power to terminate the declaration because they were also beneficiaries, and so it was part of the debtor's estate. You know, those benefits under the declaration. Well, that didn't get them anywhere. They did in fact terminate it with the approval of the bankruptcy court in the sale order. So, you know, they did in fact seek approval, and the bankruptcy court approved the termination within the sale order. And beyond all of that, you know, what they haven't, you know, the other part here is, you know, they can't cite, one, CCH has no answer to the employment at will cases. You know, all they've ever said in response to that is, well, you know, just because the declaration could be terminated doesn't mean that it would be terminated. Well, okay, I don't know, just because an at-will employee could be fired, likewise, they might not be, you know, for any reason. The fact is this remained terminable at will for any reason, no reason at all, at the pleasure of the declarants, here the debtors. And that is the same thing that those employment at will cases say over and over. If you look at, you know, Roth, Pataki, and then Youngblood, which is cited in our brief, there was a magistrate judge serving a 2-year term, you know, but even though it was supposed to be a 2-year term, it said at the pleasure of the city council. You know, what the court in Youngblood said was, well, at the pleasure means that doesn't, you know, even if it's before the end of the 2-year term, you should have understood at the pleasure meant, you know, at will of the person. And then finally, I think it gets lost in all of this, that CCH did receive notice. It received publication notice that nobody disputes. Publication notice was given on in January 2021, prior to the hearing on the sale order. And likewise, it received notice because this termination was recorded of record in Collin County. The termination of this declaration was recorded of record there, and so it was on constructive notice of that termination from February 2012 forward. Thank you.
Thank you. Mr. Fourmaux, you have 3 minutes.
Sure. The sites that I didn't have at hand earlier for the discussion in the bankruptcy proceeding are the June 10th, 2022 hearing at pages 125 and 190. Those are in the ROA 23-40601 at 3389 and 3454. The restatement doesn't take a position on whether an interest is...
Just so I'm clear, the citations that you just gave us was for the arguments in hearings.
The hearing on the motion to set aside in the bankruptcy court.
So was it also set out in your briefing before those courts? Or was there just some cursory reference to it at the oral argument?
I believe the terms of the declaration are set out in the briefing, but again, it was never contested that it had this status. The argument was always, yes, but it had this termination feature, and therefore that demoted it to a mere expectancy. I would say, as to the restatement section that was mentioned, that seems like a nothing, since we were just told, well, it doesn't actually take a position on whether a volitional condition makes something property or not property. But I do want to make clear that this was a present interest, not a future interest. Again, the declaration was declared in 2009, and the beneficiaries were vested with an interest in 2009. They continued to have that interest until something happened to divest them of that interest. And that's why it's completely unlike at-will employment. In at-will employment, when an employee is hired, it's not that, okay, now you are hereby vested with a right to continue employment, and then when they get fired, the the employer is now divesting them of that right to employment. That's not what's happening at all. It's rather the employer and employer agree to have this employment relationship for as long as they're both willing. And when one of them is not willing anymore, the relationship simply ceases. Nothing is vested and then divested. So I think that makes it a completely different situation than what we have here. Judge Engelhardt, I think you had asked about, was there any hearing on the seal order? Yes, there was a seal order hearing, but there was absolutely no discussion, absolutely not even an ex parte discussion of the provisions for the term that were going to be inserted about the termination of the covenant. In fact, the version of the proposed seal order that was attached to the motion didn't have such provisions. It was only subsequent to the seal hearing that a revised form of proposed order was submitted to the court. And we've cited this in our briefs, but if you have to look at...
Thank you. I was expired.
All right.
We have your case. The case is submitted.